Welcome to your Aged Care Compass podcast. Join us to find out how to support your older loved ones at home. We're going to help you make sense of Australia's aged care system. We talk about legal and financial considerations for ageing and how chronic health conditions impact your older loved ones' well-being. And we share real-life stories of where it went wrong for people and how we got them back on track. Welcome to today's episode of Your Aged Care Compass. Today we have guest speaker Joshua Auld chatting with me about estate planning. Josh was a guest speaker last year for a masterclass we hosted on the same topic, and it was really well received with lots of great questions from the audience. Josh is a solicitor based in Cairns who practices predominantly in wills and estate, as well as litigation. For the last 7 years, Josh has assisted hundreds of clients through their estate planning, as well as assisting them through the difficult times of losing loved ones and winding up their estates. Josh has a keen interest in complex estate planning and often assists business owners navigate their estate planning, as well as business succession planning. Josh, estate planning. When I think of this task, it makes me feel a little overwhelmed. It sounds complex. Is it?
Well, no, Coral, it doesn't need to be. I do have many clients who do have quite complex estates, which include various interests in companies and trusts. But when you take it back to the basic principles of estate planning, it doesn't need to be complicated. I often begin by asking clients what they want to achieve or what their desired outcome is for their estate planning, and then work backwards from there so that we can achieve that outcome. And I also work with my clients' accountants and financial planners to make that process as simple and straightforward as possible.
Okay, great. What are the different parts of estate planning that a person needs to consider?
Yep. So when you talk about estate planning, there's really 4 main parts to it. And perhaps the one people are most familiar with is the will. And this is possibly the most important document to factor into your estate planning. So this is the document where you appoint someone to be your executor who will act as the trustee for your estate when you pass away. And it's their job to distribute your estate in accordance with the directions that are outlined in your will. The second, and possibly as equally as important as the will, is the enduring power of attorney. And this is a document that you put in place while you're alive and while you have capacity, and you appoint a substitute decision maker who's there to make decisions on your behalf for personal and financial matters. The third document that we factor in is the binding death benefit nomination. In most cases, it's a fairly standard form that superannuation funds give out to their members, and you've got to go through that and set out how you would like the trustees to distribute your superannuation balance should you pass away. So whether it's going to be directed to a spouse or to your estate or to some other dependent. And then finally, there's the Advanced Health Directive. And this is a rather serious document that relates to end-of-life care. This is the document that you need to take to your general practitioner and sit down with them, make sure that you understand all the different considerations and all the options that are available to you for end-of-life care. So in a nutshell, those are the 4 main documents that we factor into a client's estate planning.
It sounds really comprehensive. That was really interesting. I was certainly aware of the will and the enduring power of attorney, and I had some awareness of a binding death nomination, but I didn't realise that estate planning also included that Advanced Health Directive.
That's right. And there's a couple of other documents as well that we can put in place, but they're the main ones. There's other things like a memorandum of wishes, which is a non-binding memorandum that you would leave to your executors to say that whilst you might say this in your will, you would like certain things to be carried out in certain ways. It's not binding on the executors, but people often put those in place for other minor things. And then you've got other documents like guidelines for guardians. So if you pass away and you've got children that are under 18 and you appoint someone to be the guardian, you may wish to leave guidelines to them about where you want them to go to school, what sort of medical care, all sorts of things like that. But those are sort of more minor documents that we factor in. It's not in everyone's estate planning, but they're certainly available to clients that wish to use them.
Yeah. All very important aspects of estate planning.
Yes, indeed.
Let's talk about wills. So people have options to create a will. They can see their solicitor. like you, they can buy a will kit from the post office or they can visit the public trustee. Could you explain the difference between these options?
Yep. So I may be biased, but the best way to ensure that your estate planning is as tight as it possibly can be is to go and see a solicitor. So
Yeah.
as estate planning solicitors, we know how to structure your estate. We know what needs to be put in place to achieve your desired outcome. And we can identify any other risks or options that may be available to you to stop any challenges to your will down the track or minimize any risks of non-compliance with your estate planning documents. So I always stress that whilst there's some other possibly more cost-effective options out there, certainly the best way to ensure that your estate planning is tight is to go and see an estate planning lawyer. One of the other options that you raised is to go and visit the public trustee. And personally and professionally, I do discourage this because whilst the public trustee may offer a free, simple will service, this is generally on the basis that the public trustee appoints themselves to be the executor of your estate. So whilst you're alive, that may seem great. It'll save you some money and it might seem nice and simple. But when you pass away, the public trustee then steps into that role as the executor of your estate. And I've seen numerous estates that have been under the administration of the public trustee that take a very long time to be wound up, and the costs that the public trustee charge don't reflect the work that they've undertaken. So again, it might seem like a great option to save a few dollars, but at the end of things, it can end up costing your estate a lot more, which means that your beneficiaries aren't going to get their full entitlement under your estate.
I'm really glad you raised that, Josh, because we see that quite a lot as well with people who have gone to the public trustee thinking that it's free, and then the client has died and it is revealed to the family that it's not actually a free service as well. So great that people might want to avail themselves to that option, but I think it's fantastic that you've raised this awareness so that people are very clear that it's not actually a free service.
That's right. That's right. Yeah. So the third option that you raised there as well was the will kit. I always shudder when I see someone come into my office with a will kit that they've done and they want to update their wills. And I think, all right, excellent. Let's get onto this as quick as we can. So the will kit, again, it might be another attractive option. You see them at the post office for 20 or 30 bucks and you fill it out and sign it and you think that everything's all good. But unless you properly understand the legislation and the requirements to meet a formal will, it can be very, very easy to miss one of the requirements, say to only have one witness to your will, or to not sign every page, to not properly date it, to not properly appoint an executor. All these things open up risks for challenges to your will down the track. Or if you have a will kit and a rather substantial estate where you need the will kit admitted to probate, that's where it's scrutinised by the court to make sure that it meets the requirements of a formal will. And if you miss one of those things, it may not be admitted to probate and things get very expensive after that. So summing all of that up, I think it's important just to go and get it done properly, go and see an estate planning lawyer.
Josh, just one question on those will kits from the post office. If a person completes that, what do they do with that then? I mean, like you've said, you've had clients that come into your office and say, I got this will kit. Can you take a look at it? I want to update it. Are people obliged to, if they complete this will kit, is there an expectation or a recommendation that they then go to a lawyer, or could they complete the will kit and just keep it in their cupboard at home? And then again, on their death, when their family comes across it and perhaps it hasn't been written up properly. I'm just wondering if you could just explain that process of on completion of a will kit, what does the person do with it then?
Yep. So on very few occasions, I've had some clients come in that have bought a will kit in and they just want me to have a look at it, which again, I'm happy to, but I always stress to them that it's better just to get a proper will drawn up. But in those situations, sometimes they just leave it with us to put it in safe custody, or quite often they'll just take it home and put it in a sock drawer. And when they pass away, one of their family members finds it and brings it in. And that's where we've got to go through it and make sure that it's filled out correctly. I have, on a number of occasions, got a will kit admitted to probate. So the Supreme Court has effectively put the stamp on it, saying that it does meet the requirements of a formal will. So this is not to say that it can't be done, but the risks of not meeting those requirements is just far greater than getting it done properly by a solicitor.
Fantastic. Thank you for that. Now, before we go any further, I just wanted to clarify some of the terminology around wills: executor, beneficiary, probate, intestacy, and letters of administration. Could you please explain those for us?
Yeah. So looking at the first one, executor, that's the person that's going to be the trustee of your estate. So that's the very start of your will. You have to appoint one or two people to be the executor of your estate. So quite often this is someone's spouse or their children or someone that they know very well and trust. It's got to be someone over the age of 18 as well. And that's the person that has the legal obligation to carry out the directions and the wishes that are in your will. So it's interchanged with the term trustee. Some wills will have executor, some have trustee. Sometimes in a will it will say my executor and my trustee, but for the purposes of that role, it's the person that's to carry out the directions and the wishes that the will maker puts in the will. Then the other, I guess, term that's contained in the wills is the beneficiary. So that's the person who's actually receiving the gift. So the executor doesn't have, generally, unless they're a beneficiary themselves, generally they don't have any legal entitlement to the estate. So they're the trustee for the estate. They have to call in all the assets, pay out all the debts, and then distribute the estate to the beneficiaries as the will maker intended. So the beneficiaries simply are the ones that receive the benefit of the estate. There were two other terms that you mentioned there, probate and letters of administration. So where probate or letters of administration is required to administer an estate. So if there's substantial assets in an estate, generally the people, the places that hold those assets, whether it's a bank or nursing homes, places like that have a bond that someone has left with them when they pass away, they'll require the estate to go and get probate or letters of administration. So really the only difference between the two of them is probate is a process that you go through with the Supreme Court where there's a formal will in place and you have to go through all of these steps and then submit an application to the Supreme Court where they effectively put a certificate on the front of a copy of the will and put a stamp on it to say that this is the last valid formal will, and the person named to be the executor is therefore entitled to go ahead and administer the estate. So it also provides the executor with a bit of certainty that they're the ones that have been appointed. There's no risks that someone else might come out of the woodwork and challenge their entitlement to that role.
FlexiCare is a not-for-profit organisation which supports older people living in Brisbane's southern suburbs to live their best lives in their own homes and communities. FlexiCare don't have grand plans to be the biggest aged care provider. They want to be known for treating each one of their participants as an individual who they get to know well. They answer their phone calls personally when clients ring them. They give their clients easy access to a home care partner who can work with them to deliver the best mix of support possible. If you're in Brisbane South and want to know more, give their friendly team a call on 07 3422 8400 or check out their website flexi.org.au.
If someone doesn't have a will in place when they pass away, that's where the term intestacy comes out. So if you were to die intestate, it means you've died without a will. So the Succession Act provides some steps and some guidelines of what happens in those circumstances. So it sets out who would be the administrator of your estate. So it's a different term to if you have a will. So if you've got a will, you'll have an executor. If you don't have a will and you have to go through the process to get letters of administration, you'll have an administrator of your estate. It's the same role, but it's just called something different because you've got to go through a different process there. So the way you go about it, it's a slightly similar application to probate, but you've got to go through and identify who those people are that have an entitlement to be the administrator and to be the beneficiaries as well. So it's essentially, it cascades down. So your spouse would have the first entitlement, then your children, and so on and so forth down. So you've got to go through a process of identifying who those people might be in relation to the deceased. So you've got to go, right, I've got a spouse. They say that they are the spouse. They go ahead and make the application. If they don't have a spouse, then you've got to go through and prove that they've got 2 kids. They're the only 2 biological kids. So they're the ones that have the entitlement to be the administrator. So again, similar process to probate, but it's just if you don't have a formal will in place at the time that you pass away.
And Josh, just to clarify that, if a spouse or the adult children became aware that my husband, my wife, mum or dad didn't have a will when they died, would they then come to a solicitor and say, help get me sorted? I mean, that it would be, to me, I just think, my goodness, that sounds incredibly complex. I wouldn't know where to start. I'm just going to go and see a solicitor and get them to help me get this sorted.
Yep. Yeah, that's certainly the best way to go about it, because even before making an application for probate or for letters of administration, there's some steps you have to go through in terms of advertising that you're going to make that application. You've got to contact any other people that might have an interest in the estate. So unless you were a super guru in this area, you would definitely want to go and see a lawyer and get their assistance with this.
Definitely. I'm hearing that loud and clear. So, Josh, you were the instructing solicitor for a groundbreaking case that set the first precedent for admitting a video will to probate in Queensland. I would love for you to tell our listeners about this situation.
Yes. So I found myself involved in this case very early on in my career. Basically, what had happened is that there was an elderly lady that was coming to the end of her life, and she didn't have a formal will in place, and she didn't want to pay a solicitor the fee to draw up a will. So she found herself in hospital, and thankfully she had a very wise friend that came down to see her that was asking whether she had a will in place. That lady said no, she didn't, and she didn't want to pay anyone to do it. The public trustee certainly wouldn't come out to the hospital and do a bedside will. So this quick thinking friend decided to whip out a mobile phone and step through what were actually the requirements under the legislation for what you need to put a will together, except it wasn't written, it was in video form. So she went through and said, what's the date, what's your full name, what's your address, and then so on and so forth. And she articulated what she otherwise would have put in a will, but recorded it via video. But because that didn't meet the requirements for a formal document under the Succession Act, we had to take that recording and a transcript of it to the Supreme Court in Brisbane and make an application that the recording and the transcript be admitted to probate, which after a very lengthy process it was. And we successfully got the first video will admitted to probate in Queensland. But the flow-on effect from that was that I think at the time the lady was quoted about $400 or $500 to do a will just to get the estate admitted to probate, not doing any of the administration, not selling any property or winding up bank accounts or anything like that, just to get the tick of approval for her executor to start acting, cost upwards of $20,000 for her estate to instruct lawyers to do that. So I say that again with all the risks of appointing the public trustee or a will kit or not having a will in place. If you don't spend the money and get it done properly at the start, your estate can be eaten up in fees after you pass away.
Gosh. $400 or $500 and then ended up costing nearly $20,000.
Right.
Ouch.
Yeah. Yes.
Josh, in what situation would a person not be legally able to create or change their will?
The main situation that would cause that would be if you didn't have capacity. So if you find yourself unconscious, or if you've got some sort of cognitive disease where you've been deemed by your GP or geriatrician that you don't have capacity, you can't make a will because you don't understand what you're doing. It just opens it up to a challenge down the track as well. So this is a situation where we do often have people come in that have been diagnosed with dementia and Alzheimer's, and we're aware of that. And to make sure that we're fully aware of their capacity, we send them off to a GP or a geriatrician to get their capacity tested before we take instructions. And there have been situations where they come back and the GP or the geriatricians determine that they do have capacity. So great, we can go ahead and put a will in place. But there have been situations where that's just not the case. So that's the main situation where that would arise.
Yep, great. Let's talk about appointing an attorney. Now, when I think of an attorney, I think solicitor. But in substitute decision-making terms, we're talking something else here, aren't we, Josh?
Yes, that's right, and you're not alone there. There's quite a few people that think that they're appointing their lawyer to do something for them, but what they're actually doing is appointing a substitute decision maker. So under that document, the attorney will be the person who makes decisions for those people on their behalf if and when they lose capacity.
Yeah. Excellent. The terminology for substitute decision makers varies from state to state and territories. So I just wanted to highlight this for our listeners. Depending on which state or territory you reside, there may be one document or there may be two documents that cover decisions relating to healthcare, residential and accommodation arrangements, and personal affairs. In practical terms, what kind of decisions might a substitute decision maker make, Josh?
So yes, in various states and territories, the documents are called different things. And I do know that in New South Wales and I think WA as well, possibly even Victoria, they're two separate documents. I think
Yes.
it's called an enduring power of guardian and an enduring
guardian.
administrator
Yeah.
or something like that.
Yeah.
But here in Queensland, we have the one document. All those powers are contained within the one document. You can separate them, but it's just one document instead of having to fill out two. So the decision maker under that document has the power to make decisions really for two areas. One is financial. So some examples of that would be an attorney can deal with paying bills if you lose capacity and a bill needs to be paid. They can manage property or investment. So if you lose capacity and need to go into care, they can sell a property to be able to fund that. And they can do other things like prepare your tax returns and meet with your accountant as well.
Right.
So that's kind of the financial side of it. And then secondly, there's the decisions for personal and health related matters. So this often relates to living arrangements. So people, again, who are becoming elderly or lose capacity, the attorney can make decisions of if they need to go into a care facility or something like that, or just their general day-to-day care, other things like sporting and recreational activities, and some medical decisions relating to treatments and medications as well.
Excellent. And is there a certain point where the substitute decision maker can begin making these decisions?
Yep. So that's really up to the principal, the person who's making the document. So under the document, it provides that someone can start acting immediately. They can start acting when you lose capacity, or they can start acting at a certain date. So I've seen all three under the documents. It just depends on what the principal, the person making the document wants.
What happens if a person no longer has decision-making capacity? Let's say they have advanced dementia and they haven't appointed a substitute decision maker. What happens then, Josh?
Yeah, so in this situation, if, say, for instance, someone's mum lost capacity and didn't have an enduring power of attorney in place and they needed to move them into a care facility or pay a bill or something like that, they would actually have to make an application to the state's relevant guardianship tribunal. So in Queensland, that's the Queensland Civil and Administrative Tribunal, and they're the ones that have the jurisdiction to appoint guardians or administrators. So they would put the application together and go before the tribunal and explain that it needs to be put in place, and the tribunal would then appoint them as the guardian or administrator for their parents.
Sounds a little complex to me. Is that something that the person, the family member, can do themselves, or would someone come to a solicitor to get some advice about how to do that?
Yes, I think in the first instance, a lot of people would go and see a solicitor. UCAT is supposed to be a self-represented tribunal, so generally you should be able to download the forms and fill them out yourself. But when you're often going through these difficult situations, it's sort of hard to know what supporting material you might need or how to fill out the application, where to lodge it, where to start. So a lot of people will come to a solicitor, and at the very least, we can assist with filling out the forms and telling you what supporting material you might need, whether you need to go and see a GP or a geriatrician, whether there's other people you may need to contact to notify them that the application's being made. But often they would come to us in the first instance, yes.
Yes, I think I would too. So, Josh, for what other reasons might a person or their family end up in a civil and administrative tribunal with regards to decision making?
Yeah, so The most common situation is what we've just gone through, where there's no enduring power of attorney in place and someone needs to go and get appointed. But there are other situations where you might find yourself there. So it might be for a review of a decision that's been made. So
Yes.
if someone has been appointed as a guardian or administrator, there might be certain conditions attached to it, like it only lasts for 1 or 2 years, or it needs to be reviewed every 6 months or so. So you may need to go back and have the situation reviewed by the tribunal. You can have someone's capacity determined. So if there's a question about someone's capacity, you can make an application to do that. Or if someone's not acting in the best interest of a principal and you want to get someone else appointed, you can certainly go and do that as well. But it's the main application that we see is for someone to be appointed as a guardian or administrator.
Okay, thank you. And what about revoking an enduring power of attorney? In what situation might this happen if people aren't aware? Like if they're not aware that they might be the EPOA, but actually they can get revoked. So what would those kind of situations look like, Josh?
Yeah, well, the first would be upon someone passing away. So an EPOA ceases to exist when someone passes away. That's when the will comes into effect. Another situation where you might want to revoke an EPOA is when you get married or go through a divorce. That's a good sort of point to revoke your EPOA and consider appointing someone new. If someone you've already appointed as an attorney under that document passes away or loses capacity, if you don't have a backup appointed in that document already, you may want to revoke it and put a new one into place. Or if your attorney is conflicted in some way, if they become a paid healthcare worker for you or something like that, they're automatically conflicted from acting in that capacity. So there's some situations where an EPOA may be revoked.
Okay. Josh, this has been a fascinating discussion. Thank you. It's clear taking the time to get one's estate planning in order shouldn't be relegated to the too hard basket. I hope you, our listeners, might feel less daunted about this process. We've included state-by-state links in the show notes so you can check the requirement for appointing a substitute decision maker for your location. And we've included Josh's contact details should you want to follow up with him. Josh, thanks for taking the time to chat with me today.
Thanks for having me.
Hey Care community, thanks for listening to this episode. So you never miss a show, make sure you subscribe to our podcast. If you'd like to know more about what we do, head to our website, cmeacn.com.au.